Hello and welcome to the Wire Talks. Last week, a BJP MP, Nishikant Dubey, attacked the outgoing Chief Justice of India, blaming him for what he called civil wars. A few days later, he called a former Chief Election Commissioner, S.Y. Qureshi, as being a Muslim commissioner. Dubey was not the only person to be critical of the Chief Justice, no less than the Vice President Jagdeep Dhankar, who, by the way, is a lawyer. In an address to the Rajya Sabha interns, made strong remarks about a judgment of the Supreme Court. And he called Article 142, which the Supreme Court had recently used, a missile in the hands of the court. Why these sudden attacks on the Supreme Court? DMK MP P. Wilson said it succinctly. Hail the Supreme Court when it suits you, ridicule it when it doesn't. Tensions between the executive or the legislature and the judiciary are not new, nor are they limited to India. We have an example in the United States right in front of us. But have Dhankar and Dubey gone too far in their criticism of the judiciary? I invited senior Supreme Court advocate and well-known columnist on legal affairs, Sanjay Hegde, to be my guest on this podcast. Hegde has written about this in the newspapers and on social media. Sanjay Hegde, welcome to the Wire Talks.
Thank you for having me, Sidharth.
My first question, I want to start with a blunt one. Has the VP gone over and beyond his role by criticizing the Supreme Court, the Chief Justice, and that too in such terms?
Well, the VP has certainly gone beyond his constitutional role. His constitutional role is as the presiding officer of the Rajya Sabha. He is also, even constitutionally, he can be the president if the necessity so arises. But when in constitutional office, you do not criticize other constitutional institutions. Now, just imagine if the VP were to say that no work exactly gets done in the Lok Sabha, and that the Speaker of the Lok Sabha conducts the House in such a manner that nothing ever happens, then could the system handle such tension? Now, if you can't say things about another constitutional house, can you then say things about the judiciary? It is normally not done. Yes, the judiciary is not about blame or criticism. And then there are plenty of people who criticize it. There are academics who criticize it. There are practicing lawyers who criticize judgments. But the main thing is that criticism from a constitutional functionary or a constitutional institution of another constitutional institution rarely happens. So he has certainly gone way beyond his remit.
But don't you think also one must point out the language he used and the occasion? He's talking to Rajya Sabha interns who are coming in. They are newcomers to the system. They will perhaps have a long career ahead of them. And they start by listening to the presiding officer speak in such terms to call it a missile in the hands of the Supreme Court, simply because you or perhaps the people you represent, not in terms of constitutional posting, but otherwise, are unhappy with a particular judgment? The language, I'm talking about the language and the place.
Absolutely. The language was intemperate, to say the least. And what does he mean by unguided missile? Article 142 is specifically there for a reason, so that the Supreme Court can do whatever is required in the interest of justice. Now, 142 was also used by the Supreme Court in the Ram Mandir matter. In the Ram Mandir matter, they say that both sides got a decree, the Hindu side as well as the Muslim side. And then the Supreme Court used its special powers under 142 to say that you have got decrees, you have both of you have proved your respective cases to a great extent. Therefore, how do we mold the relief? And we mold the relief by saying that the Muslim side will get twice the amount of land at some other place. The Hindu side, even if it gets the disputed land, will use the land through a trust, and a temple will be constructed in a particular format. So therefore, the 142 has been in the constitution right from the beginning. 142 has been used for even such mundane things as sometimes dissolving marriages. It is there precisely because the constitution realizes that everything cannot be written down in black letter law. The Supreme Court says that if there is a law, we do not use 142. It is only when the law does not provide any written answers that we use 142 in aid of the law and in aid of justice. To say that it is an unguided missile is certainly not on. He seems to imply that judges go by their whims and fancies, and they have this magic wand of 142 where they can say abracadabra and then turn a man into a woman or vice versa. That's not how 142 operates.
So I speculated in my previous question on possibly why he was sounding so angry, upset. What is your own take? What is his? He surely, as a lawyer, known that it was used in the past, and that why the 142 Article 142 is there. He surely should know. Why do you think he was so upset?
No, it's not that he's been upset for the first time. He's been saying things about the judiciary for quite some time. Now, you see, what is the function of the judiciary? If the entire constitutional machinery is a car and the executive is both the accelerator as well as the steering wheel, what the judiciary does is to play the work of the brake. If the car is likely to go off the road, or if there are hazards ahead, then the brake comes into play. Now, people who like to think that they have the steering wheel and that the accelerator can go full throttle do not necessarily like the brake. The vice president has been saying things like that there is no basic structure of the constitution. He has been saying that things like about the collegium and the manner of appointment of judges. And quite frankly, many of us think that he seems to be auditioning for a bigger job than the one that he has.
Again, so Sanjay, I would say that is your conjecture.
Speculation.
Yes, and
that may be my speculation, but please look at what he's done in constitutional office. In West Bengal, where he was governor, he did almost the same kind of things that the Tamil Nadu governor did. Now, to say that an unelected governor has powers to stymie an elected government at the state level is certainly carrying things too far. But then many of the governors, especially in the non-BJP ruled states, seem to think that they had a divine mission from Delhi to not allow things to happen or to cause the maximum possible inconvenience. It is there that the Supreme Court only reiterated earlier judgments of the Supreme Court. There's a 7-judge judgment in Shamsher Singh's case which says that, look, we do not follow a system of a presidential form of government, or our governors are not executive governors. We follow a parliamentary system of democracy, and in almost every action which is expressed in the governor's name or in the president's name, they are actions which are of the government of the day. The government of the day gives advice to the president or the governor, and he is obliged to follow it irrespective of whether he likes it or not. The Supreme Court has also said in this judgment. It referred to a time when President Rajendra Prasad had his doubts about the Hindu Code Bill. So he sought the opinion of the then Attorney General, Mr. Setalvad. And Mr. Setalvad then told President Rajendra Prasad, look, in a parliamentary form of democracy, the president really has no role on policy. The then president then accepted the advice, and the Hindu Code Bill went through. Now we have had a 75-year plus constitutional history. To now go back and start revisiting old questions is simply not on. The Supreme Court went by past precedent, and I don't see any specific reason for the vice president or the political establishment of the day to take umbrage at the judgment.
No, now it leads me to my next question, moving on from the vice president, that a few days later, after the vice president made those comments, a BJP MP who perhaps has, who's just gone on the rampage by making statements. So first he made a statement against the Chief Justice. Let's stick to that. He said the Chief Justice is causing civil wars. What does that even mean, firstly? And why do you think, seen in conjunction with the Vice President's statement, this is sounding extremely dangerous?
See, it's not only the Vice President and this MP. It is there was another MP also who's made similar comments. And if you look at the campaign launched on social media by the IT cell, it is a concentrated attack on the judiciary and the Chief Justice. It may well be that the Chief Justice's questions in the Waqf matter may have again put the brakes on what the ruling party saw as its dominant narrative, blessed by a parliamentary majority. They think that since they have a majority in parliament and can get legislation through, they do not have to pay attention to the constitutionality of the legislation. Yes, you have the power to pass legislation, but every citizen has the right to petition the courts saying that this legislation is unconstitutional, it has not been passed through the correct procedure, or that it is violative of certain fundamental rights. And it is for the courts in judicial review thereafter to examine these questions. So the same process was happening with the Waqf bill. The court so far has not passed any stay order whatsoever. The court has only recorded the Solicitor General's statement that certain sections of the Waqf bill will not be given effect to till the next date of hearing, by which date the Union of India expects to put in a reply to the petitions, take their defense in writing, and then maybe the court may or may not pass an order. If it doesn't think that an order is necessary, it may not pass an order. So the dominant narrative is unused to its narrative getting checked constitutionally, and possibly that has led to this kind of attack. Mr. What's his name? Mr. Dubey is only a battering ram. But yes, you're right. Is there some kind of pattern which can be discerned? I only bring you back to that old James saying in one of those James Bond books, that the first time may be happenstance, the second time may be coincidence, but the third time is definitely enemy action.
Yes, a declaration of war. That's true.
Yes. So now please note how many times this kind of attack has happened.
Perhaps, if I may take a step forward to say, maybe the dominant establishment is not used to this kind of questioning.
Absolutely. Absolutely. They are unaccustomed to questioning. Their answers are always loud and contemptuous.
So, don't you think? I think this is a point that you have made. Many others have made. What does this? How does this reflect on Indian democracy as it is today? Because you have the Supreme Court, for whatever it is. Sometimes its decisions, please you. Sometimes they don't. But it's the highest court in the land, and it has, over the years, earned tremendous credibility. But it is definitely an institution of the state, and you are constantly ramming it because something that happened that did not please you. What does it do to Indian democracy?
Well, it does tell you that Indian democracy is not in a very healthy situation. We should not necessarily confuse democracy only with elections and their outcomes. Elections happen once in 5 years normally. But what happens between those 5-year periods is also the democratic working of institutions. So today we have a rampant executive backed by a legislative majority, which thinks it can run roughshod over all other institutions. So anything or everything that is said about any policy decision, the answer is always, oh, but we have a majority in parliament and we've been elected for the third time. You have been given a majority in parliament to work a government in accordance with the constitution. And we have institutions like the judiciary to ensure that you work only in accordance with the constitution and not in opposition to the constitution. So, to answer your question, we have a democracy which is more an electoral autocracy, that it gets validated by winning elections, but is not accustomed to functioning in a democratic manner between elections.
Now, is this clash between the executive, or in this case also the legislature or members of the legislature, and or one constitutional body against another, are these kind of internecine attacks unusual in India?
They have not been seen for quite some time, but they're not necessarily unusual. We've seen a different version of it in the late 60s and the early and right up to the mid 70s. You had the judges of the then Supreme Court being attacked as being rightist, not progressive enough, not being committed to a socialistic pattern of society, being solicitous of property rights, and not looking towards the greater good of the greater number. So you had Mr. Mohan Kumar Mangalam, Indira Gandhi's then law minister, calling for a committed judiciary. Mr. Nani Palkhiwala in those days called it a judiciary made to order. So now we seem to be wanting to go back to those days, but even if economically we are not going back to a full-blown version of laissez-faire capitalism, socially we've gone towards the right, towards religious fundamentalism, and we seem to think, or a great mass of those who vote for the ruling party think that the judiciary's job is only to rubber stamp whatever the ruling party says is the law of the land. So, quite apart from the rule of law, we now seem to have the law of the rulers.
But if my memory serves me correct, I mean, I was not a journalist in those days, but if my memory serves me correct, after reading that part of India's history, even people like Dr. Mohan Kumar Mangalam or any other MP who were calling for a committed judiciary, committed to the socialist idea, committed to the idea of being not just in tune with the government, if I may say, put it that way. I don't think their language was as crass. Would you say?
Of course not. Language, the crassness of language is possibly not only a fault of the currently ruling party, but language has been coarsened in normal discourse also. These days, everything is about emoticons and gifs and whatnot. And you see people punching on the face and all kinds of things like we will show you your ox, which is short form for aukat. So we seem to have coarsened our conversation, and our leaders and our parliamentarians seem to have taken no trouble to speak in parliamentary terms. In fact, the more unparliamentary you get, the more likely you are to get noticed by the public, especially on social media.
I think you mentioned while we were talking about this earlier, that which I mentioned in my introduction, that in the United States, the Trump administration has simply refused to do what the Supreme Court has asked it to do in the bring back the person Kilmar Garcia, who was deported to Venezuela due to an administrative error. Not to Venezuela, I'm sorry, to El Salvador.
El Salvador.
Yeah. So they have simply refused. And now we look at the irony of it all, because in the United States, you can put your chosen ones with a particular point of view, with a particular ideology in the Supreme Court. So you have rightist judges, you have judges who are not rightist. So in this situation, too, if the Supreme Court says something, the administration, the executive simply refuses to acknowledge it. Now, this seems to be, and I'm sure it happens in other parts of the world too. Is this a normal kind of push and pull within a democratic system?
No, when you begin to push down your judges, that is when autocracy says we will brook no kind of check. So whether it is Trump in the United States, Netanyahu in Israel, or Mr. Erdogan in Turkey, there have always been times when the rampant autocrat seeks to discipline his judges. Right across our border, we used to have, in the days of Ziaul Haq, for instance, he insisted that all the judges take an oath in the name of the chief martial law administrator. There were a couple of judges who refused, and then they resigned. One of them was Justice Dorab Patel. So Mr. Fali Nariman had that incident where after Justice Dorab Patel resigned, he got a call inviting him for dinner at the presidential palace. So he put on his good suit and quite slightly shaking and shivering, he told his wife where he was going for dinner. but he had a very good dinner with General Ziaul Haq, and Ziaul Haq came out to the porch to see him off in his car and told him, Dorab, if there's anything that you want, please tell me. So it is not as if dictators do not know when judges cannot be moved and when judges stick firm to their constitutional oath. The autocrat may respect the judge's choice, but they will certainly want such people out of the system, number one. Number two, they will ensure that their disapproval of such independent judges is communicated to the other judges, lest they too get too independent themselves.
Yeah. So where do we see? The Chief Justice will be retiring in a month or so. Now, where do we see this? The battering rams like Nishikant Dubey or the Vice President, who, as you said, has a long-term goal perhaps in his mind. The social media, which is the IT cell. Where do we see this heading now? What in your mind? Because this government is very much there and the Supreme Court is very much there. Where do you think this is heading?
Well, it will all depend on A, the response from the court institutionally, and B, it will also depend on what the people want. See, again, giving you an example from Pakistan, where you had a line of judges from the brilliant Muhammad Munir, who sort of justified everything that military dictatorship did. They even invented something called the doctrine of necessity to bless whatever the military dictators of the day ordered. But then they kept bending and the ask kept getting bigger. Till one day the military dictator Musharraf just pushed the Chief Justice out of office, Chief Justice Iftikhar Chaudhry. It was at that time when the Chief Justice resisted, and then the bar resisted, leading to the lawyers' movement, that General Musharraf finally had to go. People get the constitution that they deserve and that they want to preserve. If the people themselves encourage such behavior on the part of their representatives, very often you may see the judiciary say, then why do we stick our necks out? But if, on the other hand, such behavior gets discussed, such behavior gets talked about and disapproved, that too gets communicated. And you may very well see the judiciary standing up for the citizen. It's a kind of two-way street. If the citizen stands up for the judiciary stands up for the citizen. Otherwise, if the judiciary and the executive get extra cordial with each other, that is when the rights of the citizen get eaten up. Many years ago, when Chief Justice Venkatachalaya was being sworn in, the then Prime Minister in his welcome speech said that he hoped for a cordial relationship with the judiciary. Back came the response in the Chief Justice's speech. He said that the relationship between the executive and the judiciary could never be cordial. It could only be correct. So that is the kind of response which gets understood.
Yeah, but in that particular context, what is the bar in India? Let's say in the Supreme Court, for example, what is the bar saying? Have the lawyers reacted? Has there been any kind of personal or within among lawyers or institutional response to this kind of crass hitting out at the Chief Justice, who, from all accounts, from what I understand, is quite well respected.
Yes, the Chief Justice is quite well respected. He has been Chief Justice for a very short time, since November last year, and he will be there only for a short time. He will go out on the 13th of May. So the Bar Association, the Supreme Court Bar Association, and the Supreme Court Advocates on Record Association have both come out with resolutions in support of the Chief Justice and condemning Mr. Dube's statements. They have called upon the Attorney General to authorize the prosecution of Mr. Dube under the criminal contempt laws. So I don't think that the bar has been found wanting currently.
And will there be any action on that front?
Well, the Attorney General may well be examining the case, asking for his permission before criminal contempt proceedings are filed in court. I do think that he will find it very difficult to turn down that request. For all you know, he may very well say that no, I won't give you permission, but I will do it myself. That is what what a strong Attorney General can do, because you must remember that the Attorney General is not merely the chief law officer of the union government. He too holds a constitutional post. He is the Attorney General for India. His clients are also the people of India. He can be summoned to Parliament, and he can address Parliament when required to. So as a constitutional functionary, I suspect that he will come to the defense of another constitutional organism.
Well, let's see, because to my mind, I think the short and the medium and the long term view on this has to be taken. I mean, I'm glad that you have looked at all these possibilities, which can impact in the immediate term what the Attorney General does, but more in the long term what it does to this country and its democracy. So thank you very much, Sanjay. That was a pretty, a very well explained for the lay listener what all this means, because it is somewhat shocking to hear not just the IT cell. We can even understand the battering ram MP, but for the vice president, a constitutional post holder, to make such statements is somewhat shocking to read and to hear. So thank you very much, Sanjay. I hope all the concerned people pull back at this stage and this does not go any further. That was Sanjay Hegde, well-known lawyer and columnist. And we'll be back again next week with another guest. Till then, from me, Sidharth Bhatia, and the rest of the Wire Talks team, goodbye.